Please rise. Mr. Teeters, would you please lead us in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. I hereby call the order of the 8-18 public hearing of the City of Prescott Board of Adjustment. The board members present this morning are, from my far right, Tony Teeters, Raymond Everett, Johnny Forker, and my name is James DiRienzo. I'm the chair. This is an open public hearing and is being tape recorded and videotaped by the city. The proceedings are being televised by representatives of the public media, the public, local cable, and our radio stations, and may be rebroadcast. The number of board members present this morning are 4. In the audience this morning, we have Tom Geis, Community Development Director. We have George Worley, Planning Manager. We have Frank Hall, Community Planner. And we have our competent Administrative Specialist, Darla Eastman. And we also have Mr. Petracki, which is an Assistant City Attorney. All parties wishing to be heard on the issue are required to raise their hand and be recognized by the chair prior to speaking. Speakers will be expected to state their name and address for the record so that we may know who is speaking and be able to contact them at a later date if necessary. Please turn off all cell phones or electronic devices. And if you have not already done so, please sign the attendance roster in the event we have to contact you in the future. Did I miss anyone else in the audience that's here from the city? Great. First item on the agenda this morning is the approval of the July 21st, 2016 meeting minutes. Do I hear a motion to approve the minutes?
So move.
Second.
We have a first and second. Any discussion? I have an issue with one of the items on the minutes. There was a dimension on the minutes and on page 2 where Bill Watson mentioned that there was a 6-inch to 3-yard above the rear yard line. He should have really said elevation measurement. I'd like to add that to the minutes. Also, number 2 is Mr. Wyant motion to postpone variance 16003, and he also gave a date. Well, he can't give a date by law. He can only suggest and recommend that it be changed, and the staff was the one that puts it on the agenda. Is that right, Mr. Petracki? Is that... It's the last item on the in the minutes where Mr. Wyant gave the date, and I don't think he can.
He didn't. Yeah, my recollection is that he did not put a date certain on.
Well, that's why I want to remove
That's
that. I want to remove that from the minutes because he can't set a date as a board member.
Yeah, the motion is what the motion was. You know, if he put a date in it, then we'll kind of reflect that. But my recollection was we didn't put a date in it specifically because we weren't sure how we were going to renotice the reconsideration. So
Okay, so it could stay in the minutes as...
I mean, Darla can go back and listen to it. If it said August 18th, then so be it. But it's not going to necessarily bind anybody.
Thank you very much.
We'll correct both of those. We can correct as Scribner's errors without objection from the other 3.
Right.
All right.
Right. So we have a motion and a second. Any further discussion? All in favor, please say aye. Aye. All those opposed, nay. Motion carries. Second item on the agenda is the discussion and possible action of the bylaw amendment. Article 6, meetings. Item number E. Currently requires 4 board members to approve a variance and/or a conditional use. So if there were 4 members only, like there are today, and the fact that the vote is taken and it's a 3-1 vote, the vote is not carried. which means it's unanimous. That's not the intention, I don't think, of what the Board of Adjustment is required as a unanimous vote. So my suggestion this morning is to make a change in the wording, which says, a majority of the total members of the board present. A majority of the board members present. So this morning, it would be 3 required for an approval as opposed to 4. So that, I'm putting it on the discussion for the board, and I'd like to be able to get your opinion on that.
Mr. Chairman, I compliment you for making that change. It's something that I've had a problem with ever since I've been on the board, because we had to, at one point, we had to have 80% approve. So.
Okay. Any other comments? I need to have a motion to approve my change to the bylaws.
I so move.
I have a motion on the floor. Is there a second?
Second.
We have a motion and a second. Any further discussion?
I will say that this conforms to Robert's Rules of Order.
Conforms to Rob's rule. Thank you very much. No further discussion. Can I get a vote? All in favor, please say aye.
Aye.
Aye. All those opposed, please say no. The motion carries. Now, what that does, by the way, it now voids the 4 number that I previously mentioned in the initial presentation. Now, this particular motion is the most current one in the bylaws. It's effective immediately. So this morning, in order to approve a conditional use permit and or a variance, we require only 3, which is the majority of the this morning. You all understand that? Thank you very much. The next item on the agenda is variance 16-003. This is a review, once again, of a variance that was presented last month. It's now been brought forward again this month. Mr. Hall.
Yes, sir. Mr. Chairman, members of the board, thank you. As the chairman said, we discussed this a few months ago, and last month, a few months ago, it was denied based on the vote of only having 4 members present. That's been changed as of this morning. Last month, the dissenting vote suggested or approved a reconsideration of this variance in order to have it come before you again, and that was passed last month. So really what we're talking about is a reconsideration of this variance for Mr. Beavers on Black Drive, who wishes to be able to park his RV in the front yard setback on a driveway pad that he was given a permit for to do just that thing, to have a driveway pad for a vehicle. But our current code only allows the parking of an RV in the side or rear yard. On this particular property, the issue is that there is no way for Mr. Beavers to get to the side or rear yard on his home. There's no possibility for him to park it anywhere else. Certainly in the street on Black Drive would not be, that street's not as wide in that area as you would like, so I think keeping it out there for security reasons and vehicular access wouldn't be the best thing either. So you've heard this before. We've heard this case back in, what was it, May, I believe, and we're back again to have Mr. Beavers, he's here in the audience, to discuss the case with you and see if there's any other discussion relevant to his request.
Are there any other questions for staff? Hearing none, is the applicant in the audience who would like to make a further comment? Please come to the podium, state your name and address for the record, please.
James Beavers, 734 Black Drive. Mr. Hall pretty much summed it up. Again, I came down here to pull a permit to park an RV on a concrete pad, got the permit to do all that. Spent about $15,000 on landscaping and concrete in order to do that, and then was notified later that I could not do that. So that concrete pad is set well back from the street. The motorhome is hardly even visible from the street. There are many vehicles that are illegally parked on properties on Black Drive. Many vehicles throughout the subdivision, motorhomes, trailers, RVs, throughout the subdivision. Numerous, dozens and dozens and dozens. I'm one of the few people, if not the only person, who's come into the city here to apply for this variance, pay the $900, do it by the letter of the law, follow the codes, follow the laws, do it above board, nothing under the table, pay the monies, get the permits, approach you folks, and do it completely legally. That's what I've done. We're spending a lot of money now to get this done. So it's not my motorhome is not an eyesore. Again, it's set well back on the property. I cannot get to the back. There's not an alley. If I'd have known at the very beginning that I could not have done this, I wouldn't have even gotten a permit. I would not have wasted the money doing all this. So there's no eyesore. As far as traffic, there's no issues with sight of the road. It is a smaller road. I think that's about it.
Thank you very much.
You're welcome.
Is there anyone in the audience who would like to comment? Please come to the podium and state your name and address for the record.
My name is Joanne Brooks, and I have lived at 707 Prescott Heights Drive since 1969. And I do not know of any other RVs except 2 in the 800 block of Prescott Heights that should be removed also. But this motorhome is hooked up to water and power. There are lights on late at night. I will let you decide what you think is going on here. But once this happens in a neighborhood, it starts becoming a ghetto. And if you walk in my neighborhood, you'll find that it is becoming a ghetto. So I think you need to take into consideration that the man is using water and power. And it is an eyesore. So that's what I have to say.
Thank you very much. Anyone else? Yes, sir.
My name is Pete Wagner. Excuse me. I live on 1224 North Side. Though Mr. Beaver, he's a neighbor. To me, it's not an eyesore. And I could point out right now, there's at least 4 or 5 RVs, trailers parked in the vicinity, real close to the road. So I don't know what the big deal is. I really don't.
Thank you very much.
You bet.
Anyone else? Yes, sir. Please.
My name's Eddie Brooks. I live at 707 Prescott Heights Drive. I live in the same block that this is happening. My objection to it is there are people living in that motorhome other than just visitors. And I think if this happens, it's going to lower the value of my property because there'll be more and more wanting to do it. That's my objection.
Thank you very much. Anyone else? Mr. Beavers.
For the record, I wish I was under oath. It's amazing that people walk up here and tell you folks that there are people living in the motorhome. Nobody, and there are other neighbors here that can prove that, nobody is living in that motorhome. It's a storage only. If I left a light on in the motorhome that's going to devalue somebody's property, that's erroneous. There are no lights that I know of ever left on at nighttime in the motorhome. There are lights left on all night long next door to my house and next door to their house.
Yes.
Based on the drug rehab house there are no lights left on in that motorhome, period. I don't know who these folks are. Appreciate the comment. There was a lot of money spent to get this thing done. The motorhome is set back. As the other gentleman mentioned, I've got a book here of dozens of pictures that was reported to the city of Prescott, code enforcement. 20 pictures, 18 to 20 pictures in violations of this neighborhood. She says there's 2. One street over, there's 3 trailers that are 10 feet from the street. There's a dumpster there that's been there 2 years. The man whose wife died 10 years ago, and he put her in the freezer. That dumpster's still there. The vehicles are still there. I've done nothing but improve and enhance this property. It will not at all create an eyesore throughout the neighborhood. Don't believe me, drive through the neighborhood. There are code violations on every street. Every other house there's a code violation. And these folks are coming up here saying that this is a big deal, it's going to de-evaluate the property. Don't agree with that at all.
Thank you very much. Sir?
As I can get up. My name is John Carter. I live at 726 Black Drive. That's my house right there on the right. You can see it.
Okay, John?
You see the house next to me? This morning there's only 2 cars parked in the front yard. One of them's been there for over a year. The guy that owns it is dead. What are we going to do with that? That's a rehab house. That's a problem too, but we won't get into that today. But I've heard some things said here this morning that I find hard to believe. There's nobody on our street has come forward and said anything. Why is it that people way up on Prescott Heights are complaining about what Beavers has got parked in front of his house? Do they drive down Black Drive to get up to Prescott Heights? Probably. Lots of people do. But we don't have anything that we can do about that. There are places in this community where they have blocked access in one direction. You know where I'm talking about.
Yep.
And people can get out, but they can't get in. They have to go another route. I've thought of that for Black Drive for years because of the traffic. Just traffic, just zooming by. That's all I've got to say, and thank you very much.
Thank you. Anyone else? Mr. Beavers, one more time.
Thank you.
Please make it fairly short, please.
Thank you. I submitted this list right here to Mr. Hall, City of Prescott, and in March of 2016. This is a list of 8 people that live on my street next door to me who all signed it and said, let the record reflect that I, see my signature below, do not object to James Beavers parking his recreational vehicle in the front yard of 734 Black Drive. And now all of a sudden you got people showing up that live 2 or 3 streets over. Amazing. And this is on the file. This is on the record.
Yeah, we have that copy in our packet. Thank you very much. Any other comments from the public and the audience? Is there any other comments from the board?
Mr. Chairman, if you're ready for our motion.
I'm ready for the motion.
Having this been on our agenda for 3 different times, I decided I would drive through the neighborhood to see whether it was, and I did. And I see no problem with what is being offered. So I move that we accept V16003.
Mr. Chairman, I also drove through the neighborhood, and I agree with you. There isn't an issue. I second.
Okay, we have a motion and a second. Any further discussion? I'm calling for the vote. All in favor, please say aye.
Aye.
Aye. All opposed, please say no. Motion is carried. Mr. Beavers, congratulations.
Bless all y'all. Thank you. Can I say one more thing? You got 5 people here. You're missing 2. I've applied to get on this board. You need help, let me know. It's all about showing up and attending.
I'm sorry I was late.
Talk to George.
Thanks for getting here.
The next item on the agenda is the conditional use permit 16-002. Mr. Hall.
Yes, sir, thank you. This is a conditional use permit, and the application is conditional use permit for a recreational vehicle park. Now, the location of the proposed recreational vehicle park is right there on Montezuma, right on the corner of, near the corner, one street down from south of Montezuma and Aubrey. As you can see, it's located here next to an office building, a current triplex, the furniture store over on the corner. That I think it's a greenish color building, just to get everybody oriented. Now, the applicants are proposing 2 small type cabins or RVs that will be designed to appear like cabins. I've been receiving a lot of phone calls about the wording of RV park, where people get a lot of conceptual thoughts about what that's going to look like. They're thinking 50 or 100 RVs. But what the applicant is really proposing are 2 little cabins that happen to be on truck chassis or wheels, sort of like a park model design, but they're going to have little porches on them, make it look like a cabin. Just for the record, this may not be the exact type that they put on there, but it certainly is going to be similar. They wanted me to make that point that this may not be the exact kind, but they're looking at making it look like a homey looking little cabin. They want to put 2 of these cabins, with Montezuma being near the top of the screen, on the property with the required parking. Their original site plan that went through staff review had their parking backing into the alley, which is prohibited by our land development code, backing into a right-of-way. So the applicants came back with a separate design to show the parking redesigned so that they can pull up next to the cabins, and some side parking to where they don't have to back into the right-of-way. So the applicant actually corrected an issue for the staff. One amenity on the site that they want to maintain are the large mature trees. They don't want to lose them. They're going to clean up the weeds. That property has been poorly maintained from previous ownership. They're already starting to clean it up, and they want to maintain the large canopy trees to keep it as more of a park camping type setting. The zoning district permits this as short-term rentals. It's in a business zoning district, business regional, and they are here in the audience today to answer any questions you may have.
Do you have any questions for staff? Is the applicant or the applicant's representative here today that would like to make a comment? Just come to the podium, please, sir, and state your name and address for the record. Thank you.
I am Clint Mary Anderson. We live at 4683 Juniper Loop, and we are the owners of the property, and we would like to put the 2 little cabins in there. These are new cabins. These are not older or anything like that. They'll be brand new. We've redone the front wall. There's a masonite wall in the front. We put wrought iron into it, make it look for the appearance to match the Prescott image. We've put up new fences on the side and back, and again, it's only 2 cabins. This is not going to be an RV park or anything like that where there's going to be a bunch of different trailers or traveling, coming and going, or anything like that. It's just going to be 2 little cabins, 1 bedroom. It would be 2 persons per cabin. The reason we're doing this is basically that so people can walk down Montezuma and have a place to walk back to without having to drive.
I have a question. When you locate these 2 cabins, excuse me, on the property, and you set the structure down, are they on wheels, or is it going to be on some sort of a foundation, or how does that work?
The vehicles are brought in on wheels, and then they're brought up. They're going to have to be elevated because of the flood zone. They will be put on standards.
Okay.
So chances are the wheels are coming off. There's a tongue on it that will come off. It's pretty much a stationary, permanent type vehicle that will be there. If for a reason down the road, something happened to the trailer, the wheels could be remounted onto it with the tongue and towed out of there. But it's pretty much affixed to the property.
Thank you. Any other questions for the applicant? Thank you very much. Is there anyone in the general audience who would like to make a comment on this particular conditional use permit application? Hearing none, can I get a motion, please?
I'd like the motion that we accept the...
We have a motion. Do I hear a second?
Second.
We have a motion and a second. Any further discussion? Call for the vote. All in favor, please raise your hand and say aye.
Aye.
Aye. All those opposed, say nay. Motion carries. Congratulations. The next item on the agenda is the PowerPoint presentation by Mr. Petracchi on the Board of Adjustment Scope and Duties Training.
Good morning, Mr. Chair, members of the board. I notice we have several new members of the Board of Adjustment, so I thought it'd be appropriate to start the first training that we do with you guys on what is a Board of Adjustment. What authority does it come from? What are your roles, your duties, and your expectations? So Board of Adjustment is created by statute. Here's the statute. Statutes are laws passed by your state legislature. And the state statute in this case requires every city and town in Arizona to establish a Board of Adjustment by ordinance. We've done that in our city code and also by enacting your land development code. Get to know this. This is really where the bulk of your duties and responsibilities will come in. By statute, the Board of Adjustment shall have at least 5 but not more than 7 members appointed by the city or town council. Obviously, we've gone with the 7-member model. So what is a Board of Adjustment? This is, if you take nothing else out of this today, remember this concept of quasi-judicial. The Board of Adjustment is a quasi-judicial body that functions much like a civil court. The board adjudicates and decides requests for variances and appeals from zoning determinations. You've done that this morning already. And these hearings are conducted somewhat, very informally, but somewhat like civil trials. The board differs from the city council in that the city council makes legislation. It creates laws that have a general application to the city. And the Board of Adjustment differs from the Planning and Zoning Commission because that's primarily administrative, and they make recommendations to the city council on most matters. So the legal authority for your Board of Adjustment is established by both state law and the city code and the land development code. Again, the primary purposes are that you are going to hear and decide requests for zoning variances. That's the bulk of what you're going to be doing here. And to hear and decide appeals from the zoning interpretation decisions by the Community Development Department. We've had 1 or 2 of those in the 11 years I've been here. So they're not going to be very common. But just know that that's out there. And there are 2 additional places in the Land Development Code where you may hear some appeals, and that's from the administrative requirements where the staff can make certain administrative decisions based on percentages of setbacks and things like that. And if somebody wants to appeal that decision, they can. And what's the other one? It's kind of a... Well, yeah, you're certainly going to be doing a lot of conditional use permit work. But as far as acting as an administrative, or as a sort of an appellate court, you're going to have the administrative decisions of the staff and administrative adjustments and appeals of administrative decisions. And again, in 11 years, I haven't done either of those two, so I don't want you to get too wrapped up in that. Yes, Mr. Silvernail?
The last bullet point.
Uh-huh.
Will there be such questions to come before us, or will it just be nipped in the bud?
The staff will catch it. It'll be nipped in the bud. Yeah. So that's not something you're going to need to worry about. It's just something you should know that, you can't do adjustments to the zoning.
Even if we wanted to?
Right. Yeah. I guess you can apply for a rezoning with the Planning and Zoning Commission and the City Council, and that's the option that you have to go that direction. So, yes, let's not even entertain those thoughts. Zoning variances, again, the bulk of what you're going to be doing. A property owner may appeal to the Board of Adjustment for variances from otherwise applicable zoning requirements. And we kind of lay these out on each case in your staff memos. You're looking for the test of special circumstances applicable to the property. And those special circumstances are defined by statute in the Land Development Code to include size, shape, topography, location, or surroundings, such that the strict application of zoning requirements will deprive the property of privileges enjoyed by other similarly zoned property. Typical examples of that include undersized lots, lots with slopes, washes, and other features that limit building size, lot coverage, or disturbed areas. So the second most important thing, other than remembering you're a quasi-judicial board, is this one. And this is where we get a lot of debate. A variance may not be granted if special circumstances are self-imposed. And that's why you guys exist, to make that finding of fact and that conclusion of law as to whether or not you think special circumstances are self-imposed. So you'll be getting a lot of traction on that one.
Can I ask a question?
Yes.
Let's say, for instance, an individual is planning on purchasing a piece of property with a house on it, and he doesn't have the actual access to the rear like we just had this, but he also has an RV, but he likes the location and he likes the price. So he purchased it and he comes in front of us. Basically, what we're telling him is, you don't get full access and use of your property. You should have known that, due diligence up front. Is that a self-imposed hardship or not? That's
going to be your determination to make as the judges and jury on this thing. You'd be looking for other features on that lot, or is it a strange lot? Are there washes? Is everyone else in the neighborhood given that opportunity to have their RV there? But more often than not, a lot of these things are self-imposed. The other aspect that you may be dealing with is more of a kind of a court of appeals decision from a decision made by the staff or the community development director. But on any appeal from a determination by this board, any aggrieved property or party, the property owner or any other aggrieved party, and that's not defined in statute, so it's pretty open to interpretation. I guess the argument would be if the court believes you have standing, may appeal the Board of Adjustment decision to, or this one is when Tom Geis, for instance, makes a determination, here's what the LDC means in my opinion, somebody disagrees with that, they have 30 days, they can come before this board, and you can affirm that decision by the community development director, you can reverse it, or you can accept it with certain modifications. So you have a large scale of power on this board. And I don't want you to forget that. Right. Right. That's it. Yeah, and George reminds us of a case that did come before the Board of Adjustment a few years ago on a sign case where the staff determined that there was a non-conforming loss to the sign, and you all considered it. What was their determination, do you recall?
I believe they supported staff.
They affirmed the staff. Yeah. And more often than not, that's kind of, staff kind of knows what they're doing.
we sort of rely on staff
right.
Unless there's a real big issue or an ambiguity, and we do that.
This gets into the kind of open public hearing laws. These Board of Adjustment decisions are open public meetings. You've got to post a public notice, an agenda, meet certain public hearing requirements established by law. So, for instance, we assign case numbers to all the variances and the appeals. We give you the names of the applicants, the subject property location. Staff will give you a brief description of whatever the request is. You have a hearing date and a location. We typically will publish a notice on the property. And by law, the agenda has to be finalized and posted at least 24 hours before the meeting. That's all open meeting law stuff. Your agenda contents are similar to the council and the Planning and Zoning Commission. You have a call to order. You take your attendance. You do your regular agenda items and public hearing items. Staff will then do some review items, or if there's anything else you want to talk about, we can throw that on a future agenda. We talk about summary or current or recent events. A lot of times we'll update you on a decision that you've made, where that kind of winds up in the real world, and then you adjourn your meetings. Executive sessions. I've been doing this board for 11 years, and we've never had to enter into executive sessions. So that's kind of nice. But you have the ability to do it if you want to. Typically, on a Board of Adjustment, it would just be for legal advice from the attorney. In executive sessions, you can kind of list it out, saying the board will break into an executive session to discuss this item for legal advice. Or the council has now kind of changed its pre-existing policy where you can just put on the agenda any item on our agenda can be voted on to go into executive session for whatever the 7 enumerated reasons you can go into an executive session or for. You know, it's been our practice to not have them. And I think if we were to have them, we'd probably individually agendize them so we knew it was coming ahead of time. But if you guys have a preference where you just want to put a blanket statement on the agenda that this board can break into executive session on any item on the agenda, let me know and we can make that change. But again, it hasn't been a real world issue. So I think until it becomes an issue, we can kind of live with the way we've been doing it. After executive sessions, you guys return to your public meetings, ask for a motion to adjourn the executive session, and then kind of get on with the regular agenda. The executive session rules are the same as with the city council. They're conducted in private. The public may not attend. Participants are generally limited to the board members, legal counsel, and the clerk. Sometimes we'll pull staff in if that's helpful. Minutes taken by the clerk do not become public. They're only available for those who attend, and they're sealed and placed in a separate filing system. All matters that are discussed in executive session remain confidential. Board members, you can't deliberate or take any legal action in executive session. You have to do that in a public session, but you are allowed to give some level of direction or receive legal advice. Public hearings, again, just know that these are public hearings. Public notice is required. Agendas are going to be set up with different sections. Board chair kind of presides like the mayor. We follow Robert's Rules of Orders when we can, as long as it doesn't violate with other laws. And the example I give is the open meeting law, and that always seems to raise its ugly head every time we do a motion for reconsideration. Because a motion for reconsideration at the same meeting would probably violate the open meeting law because it hasn't been agendized. So what we do is place it on a future agenda. So that's how we get around that potential violation. I think what was happening as a matter of practice years ago was that people would have these very long contested hearings. A matter would get voted down because thousands of people came out from the public shouting it down, and at the end of the meeting the board would reconsider it when the public was gone. And it kind of was against the spirit of the open meeting law. So that's why we put reconsiderations, like you did today, on a future agenda. And we also take that extra step of renoticing the public. And you had a few people today who were opposed to the variance. But we always err on the side of being conservative and getting as much public notice out there as we can on any item that's on your agenda. So if it ever does wind up in litigation, we can, with a straight face, tell the judge we went above and beyond what the law requires. You have to have a quorum to transact business. Earlier today, you were asked to amend your Board of Adjustment bylaws to allow for a majority of those sitting on the board to be a majority vote. You already passed that, so we don't have to talk about that too much. That's the norm in these boards. So the 4-member requirement is a bit of an anomaly. I hadn't seen that in other cities so much. Usually it's just the majority of whoever is present, as long as you have a quorum, can make a decision. You act by motion and vote. Minutes are taken, approved, and publicly available. Public comment is taken, and presentations by property owners and interested parties are given. Staff gives their presentation. If you want to, and it hasn't been a problem with the Board of Adjustment in my history here, but if it, you know, when I first started here, building was booming, so we had Board of Adjustment meetings every week with 5 or 6 items on it, some oftentimes very controversial. So if that ever becomes the norm again, you can certainly impose time limits if you want to do that. Again, yep.
So now that we voted for this change in the bylaws, do we get a copy of the bylaws, each one of the members, so we?
We'll revise them and provide you with a revision.
Okay, that's great, because,
Right.
I like to bring it into the.
Yeah, and we'll make sure the addendum to the Land Development Code that contains the bylaws will be updated as well, so the public knows what the rules are. Again, all deliberations and decisions are done in public. All right, so here's kind of some important kind of real-world things you can take from this. Because you are similar to a court, you should not have any ex parte communications prior to the hearing. And there should be no lobbying allowed, and if somebody tries to lobby you, you just should say, we're going to consider this in an open meeting, and I am not allowed to have a conversation with you until we're in the public session, and I can't be persuaded to make a determination one way or the other until that public meeting occurs. When considering an appeal of the Land Development Code interpretation, we commonly refer to the parties as appellants and respondents, or applicants and respondents. You can decide and hear procedural motions before considering a merit on an appeal. Yes?
Would soliciting a bribe from the appellant, or, you know, that can be considered ex parte?
Yes. And it would also be considered lobbying and a felony crime.
I thought we were going to get lunch today.
That's right. So again, with the appeal kind of things, which are fairly rare, you let everyone present their case. The burden of persuasion is going to be placed on the person making the appeal. You know, the rules of evidence are very informal. Whatever you think is relevant and you want to hear, you can consider. You know, we make records of the proceedings. More often than not, they at least used to be televised. So are they still televised? They're still televised on TV. That's my good stuff. No.
When do we see it?
I think they run it live.
Live and
then rebroadcast. Many times.
Oh, well. It won't surprise anyone.
All right, so you consider applications after the public hearings have closed. If it is something that requires a public hearing, again, all deliberations are public. You all can ask questions of the staff, the parties, and if they bring a lawyer to present their case, of their legal counsel. Again, if you want an executive session, we can set that up. When deliberations are concluded, all evidence is sort of in, then the chair can ask for a motion. And the motion is obviously to either approve or deny a variance, or confirm or reverse a community development director's decision. And sometimes you will approve with conditions that may have come out as you're doing the hearing. So a lot of times we give you a recommended motion, but once you hear certain things, you want to be more comfortable with your motion, you can add certain conditions as long as they're reasonable. And those are the other options to modify. Or set it for a future meeting date, or you can always table an item. Again, motion is approved or denied by a majority of the quorum of the board now. The decision must be in writing, and typically the staff will kind of prepare a written determination for you and then give it to the chair to sign. And that's the writing requirement. Good practice, and it's not always necessary if you have a good record, because you can always rely on your minutes, but have written findings of whatever your decision is. And that just makes the record a little more accurate and complete. And that becomes an issue when somebody files a lawsuit challenge to any determination you make. I think we've had 2 cases maybe go to court after a Board of Adjustment decision in 10 years I've been here.
Our letter to the applicant for written
Right.
follow-up generally will list the conditions in it. So
Right.
it's
So
very
George,
specific, and then we list them in a minute. So we have them in 2
Right.
places in writing.
So that's good. You're going to have a nice spelled out decision when you sign it, and that's very helpful when it comes to litigation purposes, because a court's only going to consider what's on the record. So you're not going to have a new trial. You're not going to be called in to give testimony. Judge is just going to say, give me the record. I'm going to look at the minutes. I'm going to look at the decision. And I want to hear the testimony of whoever from the public wanted to talk, and then make a determination.
Okay, so the chair is the one responsible to ensure that the information he's signing on that document is about as accurate as possible.
I'd say yes to that. So welcome. your other duties as assigned.
Yeah,
have
Florence
just-
prison is a bit warm in the summertime.
That's right. That's right. And after the approval and once the decision is signed, then it gets forwarded to the interested parties. And that would end the administrative process. And then if somebody wants to appeal that, it goes to the Superior Court over in Yavapai County. Any aggrieved party, as I said before, which is a very broad definition, can appeal the decision. It's got to be done within 30 days of the formal written decision. So whenever the chair signs and dates that formal written decision, that 30-day period begins to run. It's assigned to the lower court of appeals, which is basically the Superior Court, that will hear it as an appeal. And they decide on the record, and we can give argument. They usually want to hear from the attorneys, and then they'll make a determination as to whether or not the decision made by the board is going to be upheld or not. Other important considerations for this body, like the council or any of our boards and commissions, you are subject to the conflict of interest. I'm not going to get too hot and heavy into that, because if you haven't, especially the new people, had the training with the clerk, you're gonna get this a little bit in more detail, and I can always bring back my training on it to you at the next meeting as well. But just be aware that there is a state statute that talks about conflicts of interest. And that means if you or any member of your family, and the family members are defined, stand to gain or lose a property interest, or stand to gain or lose money on any determination you make, you must declare a conflict of interest. Now, there are about 7 or 8 exemptions from that. And we can go over that. But I just want you to be aware that that exists. People declare conflicts all the time. Sometimes people will accuse you of having a conflict, but you don't. And what you can do is talk to the attorney's office, and we will write you a formal legal opinion, which gets filed with the clerk, and you have the right to rely on that, and you won't assume any personal liability on any determination you make. But always just have your antenna up and give us a call if you think you may have a conflict of interest. Do you or any of your members of your family stand to make money, lose money, make property, or gain property, or lose property?
No.
That's the basic standard.
I would like to make sure that, as the chair, that when you do in fact raise that issue, the conflict of interest, that you do understand you have to leave the chamber. I don't want to have to stay there and say, by the way, get out. And so I want to make sure this board knows that you have to physically leave the chamber, and then we call you back in at the end. Is that not the way it works?
It's not a legal requirement. That is a best practice, and we absolutely recommend you do that for a lot of reasons. One is the general public, if they see you sitting there, even though you recuse yourself, making eye contact with the board, they're going to presume there may be some shenanigans up. So it's just the cleanest way to do it. Declare a conflict. Typically, our council members will leave the chambers, go sit outside, and when it's done, we'll call them back in. So please do that.
Yeah,
So
the shenanigans
that's
go
a
on
good point.
before that. I have just a little issue. The second line up from the bottom, part of you service,
Yeah.
just thought that ought to be your.
Yeah, probably. We'll clean that up. And again, just be aware that there may be conflicts of interest. Know that the open meeting law is going to. It's
Yeah, I edit everything. Sad.
It's a rough crowd.
The fact that your neighbor Bob is asking for variance does not necessarily disqualify you
Not under you.
I have some suggestions.
Somebody's got it.
And then with the open meeting law, we'll get a little more hot and heavy again into this. If you want me to come back and do the open meeting law conflict, public records training here next month, I'll do that. Otherwise, you're going to be just kind of sucked into the normal routine of being trained by the clerk and the city attorney. Let me know. Open meeting law requirements. Members should not discuss any aspect of the case amongst themselves before the public hearing, and this includes emails. Do not sit up there and chat before the meeting about something that's on the agenda. That is an open meeting law violation. All notice and agenda requirements must be strictly followed. You've got the attorney here who can help you along with that, so that's never going to be too much of a problem. Proceedings obviously are to be transparent. The entirety of the board record is a public record, except for the executive sessions. You will receive, again, more in-depth training. Oh, I actually did write that. I apologize for your service on the board. Do you want me to do the open meeting law training next time?
Yeah, I think it'll be a good idea.
All right. I can do it now, too. I've got it, but I don't want to
Well, I
keep
think
you
next
past
time
10
we'll be
o'clock,
okay.
and it usually runs about half an hour to 45 minutes.
Anyway,
Yeah, I was going to ask you that. Have you gotten your notice? Have you already done it?
we've done it.
Oh, terrific. Then, yeah.
Okay, that's fine.
I'll keep it very minimal then if you want it the next time. Otherwise, that was kind of my concern is anytime you have a new board, they're coming in a little bit behind the rest of the commission and the board. So
The
but-
city clerk required us to come to a
good.
meeting.
I'm glad Dana's cracking the whip on you guys. Any questions or comments you have about your general authority or duties or?
No, it's very good.
Yeah, I would take a look at your land development code, section 9, and there's 3 or 4 sections of what a board of adjustment does and is, and we'll be here to answer any questions. Always feel free to call the legal department if you have any concerns. We are here to help. We are the government. We are here to help.
Mr. Chairman, I suspect I know the answer, but I know someone who has a property problem with the CC&Rs
Uh-huh.
and an HOA rule. Can we consider those?
No. Those are private contracts between property owners in a certain
I knew you were
subdivision
gonna
and
say
the
that.
homeowners association. So there certainly are legal aspects to that, and I know they changed the laws recently that give at least individual property owners some greater rights to appeal through the Office of Administrative Appeals through the state. But it's nothing in your purview.
That was a great informative presentation. Thanks. man.
Thanks. All right. Thank you.
Okay, so any review items?
No, sir.
No? And we will get a copy of that revised bylaw, yes? Okay. Any summary or current or recent events or what's good, the order, for the good of the order? None? Meeting's adjourned.
We thank our clerk for coffee.
No, I didn't.